right, welcome back to the House Judiciary Committee this Tuesday afternoon, March 10th, and we're continuing to get testimony on the miscellaneous bills, specifically right now, Section 25, and we have Elizabeth Smith. I'm sorry if we put Liz down here, or is that okay? We have Liz on.
I go by Liz. Thank you.
Okay, well, Liz Smith, welcome, and
Thanks.
identify yourself for the record and where you're from, and proceed.
Thank you. My name's Liz Smith. I'm a VP and state manager of CADIC, which is a title insurance company. Thank you, Chair Lalonde, and to the committee members for the opportunity to be here and talk about this important legislative draft. So kind of backing up a little bit to what I do. So we're a title insurance company. So we work with a network of attorneys throughout the state of Vermont who perform title examinations. And should they find an issue, they come to us with that issue and we evaluate the risk of that title issue and determine the insurability of the particular property that that attorney has searched. That's a title search, marketable title determination. And so the only thing that crosses my desk on a daily basis are title defects. So we see those in numbers. CADIC insures approximately, probably around 60% of all of the transactions in the state of Vermont, residential and commercial. So we get our fair share. And, just to kind of remark on mine and my colleagues at CADIC's experience level in terms of title defects and title risk. I've been a licensed attorney in real estate for 15 years, and I've been with CADIC as an underwriter for 10 years. So thank you to Jim Knapp for his remarks. I'll try and talk about some different things, but also, summarize sort of what I think as well relative to the Kirshon decision. Starting, I guess, is that in terms of my case research that I've done, the Kirshon decision would be what we refer to as, the minority in the United States. This is not a question of first impression in the Kirshon case. This question has come in, different jurisdictions, and the majority decisions throughout the United States are looking at these two phrases within a deed: joint tenants with rights of survivorship, comma, and their heirs and assigns, are not inconsistent, and that their heirs and assigns is specific to the type of estate that's being conveyed. And the terminology that we've used and that Jim used is fee simple title, meaning that it can be conveyed to you and that you can resell it, and put simply. So the legislative testimony document that I provided last week is available, and it does cite through a majority case using an example and other treatises and legal journals. So these are, documents to support the historical nature of this language, their heirs and assigns, in order to reflect that it is an express designation of the estate of fee simple title. So those legal resources are here. I mean, I can summarize them. The majority decision, a case being cited, this is from a different jurisdiction. No ambiguity exists by reason of the particular placement of the words heirs and assigns in a deed. The words are merely a description for the estate conveyed to be a fee simple title. So the Kirshon decision, it cites to another Vermont decision that Jim referenced, which is called Kip v. Chips Estate, and that is from 1999. In that case, and this would be a type of deed that would cross my desk, there was a section in the granting clause that said tenants in common, and a section in the habendum clause that said joint tenants with rights of survivorship. That is an ambiguity. Here you have a situation where you don't know the intent of the grantor and how the grantees were intended to hold title because it lists two different things. Within that case, the court had a lot to say about that ambiguity and then went a step further and talked about the their heirs and assigns as sort of a support of their decision. The Kershaw case then took that, what we would call dicta in the legal world of sort of, another portion of a decision, but not as strong as like the precedent of the holding. And they used that and relied on it very strongly in that Kershaw decision. So, but kind of going back to what we understand from, journals such as American Jurisprudence, other whatever Corpus Juris Secundum. I mean, all of these really sort of ancient legal texts that law students, study and pontificate on and learn about in real property law. These all support the legislation that's been presented and other more practical concepts of what the Kershaw case had was not what the Kip case had. It didn't have a direct contradiction in terms of the tenancy. What Kershaw had was silence in one clause and joint tenants with rights of survivorship in the other clause. There is nothing under, United States law, property law, or common law that necessitates that the language be placed in both locations. We're looking for clear intent of the tenancy. So the concept of silence somehow usurping, the plain language of joint tenancy with rights of survivorship is not a way that a real estate practitioner would review a deed. So the legislation that says basically that it's okay if a section in the granting or the habendum clause is silent, it just needs to be placed in one, is again sort of a common law and practical approach because we're just trying to determine the intent of the deed. And if the intent says joint tenants with rights, or the language says joint tenants with rights of survivorship and nowhere else lists a different tenancy, it should be relied upon that that was the intent for joint tenants with rights of survivorship. So the practicality of all of this is that, even if I hold, for example, title with my spouse as tenants by the entirety, that even though that feels like a safe, designation, and we may not have to worry about this Kershaw decision, the reality is every title search is based on a chain of title, a series of deeds for the past 40 years. That's the marketable title requirement. So anytime now in my chain of title or your chain of title, if there is silence in one of the either granting and habendum clauses, there becomes a question as to how the tenancy was supposed to be held. And all of a sudden now we're worried about estates that weren't opened because the concept of survivorship in the past was readily relied upon, or that there are unknown heirs that may stake a claim to the title of the property, which is similar to what happened in this Kershaw decision. So I think that is, somewhat summarizes everything. I do think this is really important. So Jim mentioned that, 69 real estate attorneys that had responded. We have hundreds of agents that we work with. And so I, sent out a message to the attorneys that we work with throughout the state and heard from about 150 attorneys supporting this legislation. Before I even saw the Kershaw decision hit from the Supreme Court records, I had like dozens of attorneys calling me, asking me, had I seen this decision? What are we going to do about this decision? So I definitely think we have significant support. And I also think there is a sense of urgency to the extent that there are transactions happening right now, title searches taking place right now in the city of Montpelier and all over the state of Vermont that are aware of this case and have concerns now that every deed in their chain of title needs to be analyzed with this in mind, even though, all of the research and common law understanding majority case law in the country and legal treatises and journals say, otherwise. So not sure, I have great respect for the Supreme Court of Vermont, and in no way do I want my testimony to reflect otherwise. In this instance, we do feel that this is necessary, notwithstanding the Kershaw decision. In addition to my role with my employer, CADIC, I'm also chair of the Title Standards Committee. The Title Standards Committee meets quarterly to review case law, to review legislation, to review different practice areas specifically for title searchers and real estate practitioners. And we also have the full support of that committee as well, including, other smaller bar associations. For example, the Franklin Grand Isle Bar Association has also specifically provided support for this legislation. And I certainly am available to answer, any questions, and hopefully the documents that I provided as well can be helpful in understanding that historical reference to heirs and assigns as denoting fee simple title.
I'm not gonna, my question is not gonna be about any of the specific things here because it will show how little I understand it. My question is actually just two things. One, out of everyone that you spoke to, did you hear from anybody who was opposed to this proposed? And then my other question is,
I'm sorry, I'm going to say no for the record.
Oh, yes.
I shook my head slowly, but
and then my only other question is, I haven't read the decision, but did you get a sense that the Vermont Supreme Court had a sense for how monumental this decision was going to be?
No, I think from my perspective, so I'm a transactional attorney. The idea of, standing in front of a jury or a judge is very foreign to me. Similarly, someone who was a specific trial litigation attorney doing transactional work would also be very foreign to them. I think this is just a misunderstanding. And I also think that the Kipps case from 1999 sort of confused the decision in a way that that they specifically said in Kershaw that the facts were factually similar or the same, and that is not accurate because back to Kipps, it had an ambiguity. In one section, it said, here you go, Ian and Zachary as tenants in common. And in another section, it said to Ian and Zachary as joint tenants with rights of survivorship. That is truly an ambiguous tenancy of which the default would be tenants in common.
Yeah.
But the Kershaw decision did not have that same set of facts, but the Kipps holding was applied as if the facts were the same, in my humble opinion.
So is it fair to say that the Supreme Court found an ambiguity that the practitioners out there, all the folks we're hearing from, don't think is an ambiguity? But just to make clear, we're clarifying this now.
That it's not an ambiguity.
That there's no way to find an ambiguity with this new language in here.
Yes, correct. So for it does two things. One, it eliminates the concept of ambiguity when one section of a deed is silent as to tenancy, and then also states that their heirs and assigns is not intended to modify the joint tenancy with rights of survivorship. So using another example of sort of deed forms, so under these same treatises and journals, there are form sections. So if you go to the Vermont form deed, while it's not a statutory form, it includes the language, their heirs and assigns. One step further, Vermont has the Enhanced Life Estate Deed Act, which is relatively recent. And within that act, a statutory deed was provided. And that deed too has a blank for where you would list the tenancy and then comma, their heirs and assigns. So again, this is common language that you would find in every single one of your deeds, in my deeds, in my chain of title. But again, it has, the effect should not be to modify the tenancy that is clearly stated.
Any other questions? Thank you very much. That's very helpful.
Yeah, thank you.
Thank you.
Thank you.
Chris Delia next. Nice to see you back.
Good to see you again. The record, Chris Delia, Vermont Bankers Association, whatever Liz just said. God, I'm not a lawyer. Let me just say, first of all, we support the language in the bill. I want to thank Liz and Jim for their work on this and their testimony. We are the recipients of their work, if you will, because we're the ones that are working with the customer to do the mortgage. And in my view, this decision creates a great deal of uncertainty out there with the deeds that are currently recorded in the land records. So to be able to bring that certainty back into focus is incredibly important. While I was not doing this job when the Bianchi decision came around, I've been doing this job with Bianchi in mind, and I've lost count of how many committees I've worked with to insert corrective language to address the Bianchi decision, which was used as an example today. So we would ask you wholeheartedly to adopt this language to bring certainty back into the marketplace for the work that we do with the title community.
Great, great. Appreciate that. Questions for Chris? Short, sweet, to the point. Thank you. So do you have Laura Braddock?
Yes.
Laura, if you could join us. I'm jumping over Jennifer Pullman because I assume you're here to talk on the same thing.
I am. Thank you. I was going to say, if I waited to the end, I'd be like, we're going to have to go back a few minutes, everybody.
See, I'm paying a little attention to it. Thank you for being here.
Yes, of course. Thank you. So good afternoon, everybody. Thank you for having me here. My name is Laura Bradrick True. I am state underwriting counsel and state manager for Vermont, for First American Title Insurance Company in Vermont. My work is similar to what Liz had described her work in that I work with real estate attorneys who are my agents in Vermont. I assist them with their title analysis and title insurance risk management and like any general legal support. What comes across my desk is also problems that we find in the land records. I'm also a Vermont attorney. Prior to my being at the company, which I've been with the company for about 5 years, I was in private practice doing real estate for about 9 years. I am also here in support of the proposed amendment to 27 VSA subsection 2, which is of course responding to Kershaw. So I want to reiterate everything that Jim and Liz said too, but things that I thought maybe I could highlight regarding like the fact that this bill is needed to restore predictability and stability into the Vermont land records. And again, aligning this new statute, if it was adopted, would align with longstanding conveyancing practices. So many Vermont deeds, again, follow that common pattern of having the survivorship language in only one part, either the granting clause or the habendum clause. And then again, include that heirs and assigns terminology, which really is meant to indicate that we're conveying the full fee simple, not a lesser part of the fee. So Kershaw creates, I believe, broadly 3 systematic issues: the clouded title and marketability problem, more litigation and higher transaction costs. There could be probate delays. Title actions might be needed to be brought to resolve things that we find in the back chain. Corrective deeds, which are not always easy to obtain because we have to again find people who thought they sold the property and now we have to go back to them and get them to sign a corrective deed, which costs money, takes time. And again, court actions sometimes, whether they take months or years, they can be expensive. They can slow down the closing process. And this also creates a disruption of longstanding reliance on, again, how deeds have been drafted in Vermont for many generations. So I do believe that this amendment, again, clarifies the joint tenancy language can appear in either the granting or the habendum clause, which is what we see in practice. It confirms the heirs and assigned language does not negate the survivorship language. You can have both joint tenants and heirs and assigns in one deed. So we think that works. And it does restore the predictability without eliminating the tenancy in common presumption. Tenancy in common presumption is still in the statute. And when we do have those inconsistencies, or if it's silent throughout, tenancy in common would be the default tenancy in the deed. I also, of course, reached out to my agents when this matter came up and said, hey, does anybody oppose or not oppose? What are your thoughts? And I gave my agents a 3-day turnaround, and I got about 27 responses in those 3 days. Everyone was in support of it. I did not have any agents reach out indicating that they were opposed to it. And yeah, so again, First American supports this amendment, reducing title uncertainty, preventing unnecessary costs, and again, protecting Vermont land title as it is. Yeah.
Great. No, thank you very much. Any questions? No, I think looks good as far as all the witnesses we have. And I appreciate everybody having reached out to the communities to find out if there is any opposition. I appreciate it. Thank you very much.
Thank you.
Thank you. So we'll go to Jennifer Pullman. Thank you for being here, Jennifer.
Thank you for having me. Yeah,
More in here, but maybe just not as complicated.
yeah, no, mine, I've learned, I'm not gonna say anything about what my proposals are. I am gonna say,
Good, very good.
it is very hot in here. Please stay awake. For the record, my name is Jennifer Pullman. I'm the director of Vermont Center for Crime Victim Services. And again, thank you for having me in to testify on what's proposed in the current version of the miscellaneous judiciary bill. I did listen to Attorney Fitzpatrick's walkthrough and also Attorney McManus, and so I'm prepared to comment on all those pieces as well. With respect to the first issue that jumps right off the page, and that's that profits from crime piece. Locally, it's more the son of Sam law, where making sure that victims are able to, if somebody were to write a book, for example, about the crimes they committed, that they would not get the profits from that book, that instead the victim could civilly sue. And it occurred to us, or occurred to me when I was looking at our comp statutes when I came on, like, why is this with us? Because as you'll see, and as Eric Fitzpatrick testified to, what's in section 1 is not new language. It just got basically stuck in our compensation statute. We don't track civil suits. We don't track profits from crime. That's always been the responsibility of the AG's office. And I met with the AG's office and they were like, yeah, absolutely. That's really odd that it actually is in your comp statute. So they were completely supportive. And so section 1 simply takes that language. And as I walk through, you'll see where it's getting basically struck out of our statutes and putting it within the AG's provision. So that one felt to us like it made more sense structurally. And importantly, our board was also given a statutory mandate, and that's, I believe, in section 14, that we would report annually on what profits that had been reported in terms of, offenders in our state and what that looked like. So that, again, felt like an obligation that we couldn't possibly report on. So looking at section 1, it really ties into section 14 and 16 and just makes it really clear that, again, the AG's office is very happy to make this change and make it really clear for folks. With respect, I'm going to only speak briefly on section 8 because I suspect that my colleague, Charlie Glisserman, will speak to this. I do want to say I'm really grateful to see this language in here. I saw that it was included in a bill that's still on the wall, and it caught my eye. And we did, Center did do some research to see, are there other states that define coercive conduct differently or prohibit it, make sure that it are limiting it to calendar dates versus acts. And we couldn't find anything that would restrict that definition. So for us, we know from working with stalking victims, prosecutors tell us it's one of the hardest cases to prosecute. And we couldn't find anything that told us why, any case law, any states that said why we couldn't do this. So we strongly support this change. Turning to section 11, that's on page 13. This came up this morning, and I'm happy to be able to speak to it. And I put this on the committee page. As you can see through the context of 13 VSA 5314, law enforcement does have obligations to provide information to victims of crime. It changes in terms of how much information based on whether it's a listed or non-listed crime. The Center for Crime Victim Services has always provided a tool for law enforcement to help them meet their obligations. We've always provided forms in different variations. The current form that you'll see on your committee page, which is here and here, was the most recent iteration of that form. It came out of the Victim Notification Task Force group. And what was missing and why we made this change was because we heard so much during testimony, and Chair Lalonde will remember this before Joint Justice, that one of the big gaps in terms of victims notification was when somebody was booked and detained overnight or on the weekend. And we realized that victims and law enforcement don't even know about sometimes this information. So it simply includes, you'll see on the back on page 2, just the reference to the offender locator system and the VINE system. That is all. And again, BSP was involved in this, as well as DOC, survivors, state's attorneys, victim advocates, and Disability Rights Vermont. So this was a consensus recommendation that we would simply update the form that BSP had already been working with us to develop. It was a simple change, and there was no opposition. Everybody agreed that that should be a part of this form. It doesn't increase the obligation on law enforcement. It just changed the form. We provide training on this form at the police academy. State Police provides training to the troopers, and then we also are working with DOC and take it. I've got plenty of copies. So it's really just a tool. It's not an additional obligation. And we've tried to make it simple. I certainly don't want to increase the obligations on law enforcement. It was simply to highlight this is something that you can be aware of. And
Are they using that form now? Or is
yes. And we've rolled it out to the Criminal Justice Training Council. And so it's a piece that, again, is something that was blood, sweat, and tears by all the members. It's not a new form. It's just an updated form. And the previous form, BSP, was right in the weeds with us, developing it, making sure that even troopers could populate it from their car. Because we understand some troopers have computers in their car. I don't know if that applies to you, Rep. Oliver.
Yeah.
But it can be populated. So we tried to make it easy. Again, it went up and down the chain at BSP. So really hope that this will be something that's considered.
So just to make sure I understand that, the current form, we were just to doubly confirm has everything that is
Yes.
being requested here.
Yes, if you'd like to look at it, see.
Oh, I trust that.
No, it tracks, it always has tracked 5314, but what we learned from this whole process of looking at victim notification was that law enforcement didn't really know they could let victims know about this information. And so there'll be training to help support that, but victims didn't know. So somebody could be detained on a Friday. The victim didn't know about the offender locator system or about VINE. So it's just giving a simple tool in writing so that when somebody's in crisis, they can go back to that form and look at that. We also had it translated into 12 different languages as well, which are all available to law enforcement in the field.
Thank you.
With respect to, I'm going to skip over section 12 because that just speaks to the repeal of what was in our statute relative to profits from crime, and just jump over to section 13. That speaks to our Victims' Compensation Board. We are recommending that we change one of the definitions that's in statute from a licensed physician to a healthcare provider. You heard from Attorney Fitzpatrick what that would look like. This came from our board and especially from our longtime licensed physician, our doctor. And he's like, we all agreed it's really hard to recruit people for this role. It's not, doesn't pay a lot of money, and it's hard to find physicians who can give up their time. And he really felt that other folks who are licensed could do this role. And so for him, he didn't see, he's really been the one that's like, I think other licensed folks could do this. You don't need a doctor. And so we're hoping that that will expand our pool of potential applicants and recruits. And then going to section 14 on page 16, as I mentioned, we're just striking that obligation to report profits from crime. And again, that ties into how we're restructuring in a way that makes sense, putting things with the Attorney General's office. So getting to restitution, I am aware of the questions from earlier today. And I did speak with Attorney Fitzpatrick about those. We do not provide any reimbursement or any advance from the fund, pre-conviction. To be eligible for an advance from the fund, 3 things have to happen. There has to be a conviction and a restitution judgment order that comes from the court. We then secondarily have to verify that those losses are crime related. So even if we get the RJO, as we call it, from the court, we don't simply say, okay, here's your amount of money. We verify that it's crime related. And then finally, in order to receive an advance, it has to be, you have to be an individual. It's not a business. So we are not giving advances out to Walmart, to Target. It's an individual person. That doesn't mean that we don't collect restitution. The first individual is eligible for up to $5,000. If the loss is more than that, we'll continue to collect. We collect for businesses. We have various tools that we can use, liens, tax offsets, lottery winnings, different ways that we can help collect that. The victim always is paid first, whether it's an individual or a business. Then we will, whatever money's left, will go back into the fund.
So you'll give an advancement only after a
Yes.
conviction?
And if we
In
verified,
anticipation of the defendant paying the restitution.
yes, and then we do work with, we are doing far better than when DOC was engaging in this piece. They had about a 19% collection rate. We have about a 40% collection rate. It takes a little while. I'm not going to say it's pretty all the time, but we work to hold people accountable. But the beauty of this fund is it takes individual victims out of that immediate like tug and pull, waiting for the $5, the $20. And so it helps make them whole in a much more expedient manner.
As long as it's not pre-conviction.
No, our compensation program is pre-conviction. that's upon a finding, I should have probably just shut my mouth. That's upon a finding of probable cause. But that's not a capitalized fund in the same way the restitution piece is. But in the restitution case, there has to be a conviction. We have to verify those losses are crime related. So we sometimes get orders that relate to, well, we sometimes will get orders from the court where it's like, oh, okay, $5,000 and or, maybe there's a plea agreement, let's say, where it's like, okay, it's $5,000 in restitution. And we're like, no, we need to drill down and find out how you got to that number. So it's not a blanket check. Our funds are not healthy enough for us to do that. And we do question every expense and verify it.
Thank you.
So what we were trying to do here was, several years ago, predating me, the initial intent was it would be up to $10,000 that somebody, an individual could be eligible for. And as we looked at the health of the fund, we thought we needed to recommend a change to $5,000. That didn't happen in all areas of statute. So this is truly, again, a technical change. We have to take care of the fund, and it's really confusing for folks who we serve and support who are looking at different amounts. For the most part, I will say that most of the folks that we do serve and support, their losses are under 5,000. But we do get some really awful ones as well. But this wasn't, we looked at whether this was really impacting most of our survivors, and it wasn't to go down to the 5,000.
So can you just remind us of what regulations are in place? That it sounds like the dollar amount is up to your discretion, but for money that you get from the feds, right? Or this is fully restitution, so it's totally your rules.
Well, as far as the restitution program, that's why the fund is in the most trouble of all three funds, because we don't have any other sources other than state special fund dollars to support it. Victims compensation, we do get a small reimbursement from the feds. We do not get that for restitution. It's completely capitalized, only funded on that 15% surcharge. So that's why this fund is in the most trouble.
So the only one of those funds that comes with sort of strings attached that are not changeable is the federal small pot of money that you get.
Yes, this fund, though, is predicated on case law, so it has to be crime related. And there's a lot of decisions.
Because I know we talked about some cases where it's like somebody's killed, but it's not deemed a murder, so they're not eligible, or certain expenses are not reimbursable. Right? I know I'm pulling from sort of disparate things, but I'm just trying to sort of get a handle on how varied is it from fund to fund. Like, so somebody might be raped and then later on they're a victim of another crime and they're thinking, oh, this fund is available, but it's really a different fund.
Restitution, if it's the direct result of a crime and it's a loss, then that's eligible. So that would include expenses that victims' compensation might not be able to cover. For example, a lot of property loss, we don't necessarily cover through victims' compensation. So it's a broader pool of potential eligible expenses, but it's harder to get there.
So loss of wages might qualify.
Well, that would also qualify under victims' comp. But again, there's a lot of different pieces at play, but restitution can cover more.
But you don't have the money because people are okay.
Well, We get them to pay, it just takes a long time.
Right. Yeah.
We do have people that are only paying $10 a month.
I believe that's all the pieces that we had in here for you.
Oh, I did want to just flag something.
So on that one,
You're not gonna let me speak?
no, I'll let you speak, but I want you to speak to corrections and institutions first, because it's related to parole eligibility and victims, and that's their jurisdiction. I'm happy to put it in here, because we've done that before where they've had us put stuff in. But you need to kind of talk to Alice first, and then bring it back. Is that okay?
That's fine.
And I'm happy to talk to her as well and tell her that we're happy to do it, but it's her jurisdiction, so I don't want to step on her feet.
I have spoken with Chair Emmons, or have emailed her, and I know she's aware of the recommendation. I was hoping, since it was a Title 13 change, we could just do it here.
Yeah,
That's okay.
yeah, she has some overlap on this, but no, I have no problem in putting it in, but let's run it through her first. It's a little premature if we, because we're gonna do these last kind of items on this on Thursday. So I'll give you till Thursday afternoon.
Okay,
Is that right?
that's
Yeah,
fine.
and I'm happy to talk. I will talk to her about it as well.
You have the, I wouldn't say side by side, but the bottom and top, so
Yeah.
you know where, we're going with that.
Yes, no, exactly. And I think that it looks fine to me, but I try to respect other people's jurisdictions.
I tried to too.
I know you do, yes, you do. But when it says parole board, even if it's in Title 13, it's.
Okay.
All right, so we're gonna take another break, 10 minutes, and then we have this other bill that we will take testimony on, and if it looks fine, we will put it on the miscellaneous bill. And then we have Willa coming in for her parts at 3:45. And I don't think it'll take more than like 15 minutes, 10, 15 minutes. We'll take 5, 10 minutes.
Well, thank you very much. for your-
Yes, thank you very much. Thank you, Jen. And we'll see you again on Thursday, more likely.
Yes.
Well, what?
The only
Good to go, bye.
language